All rise. We will obey. Please be seated.
We're in open session, Your Honours.
Thank you very much. Yes, Mr. Khan.
Mr. President, if I may, there were just 2 points, with 1 minute, if I may, just that I didn't raise earlier. Your Honour, the counsel for the witness referred to certain information, and of course the defence would welcome any information to be gathered, M-Pesa records, for example. Your Honour, in relation to the timescale, and I'm grateful to my learned friend Mr. Fal, who's the expert on such matters, any Kenyan citizen can go to a service provider with a request for phone records and M-Pesa records, and normally one will get it within at most 2 days. Your Honour, the other matter is the matter Your Honour raised, that in order to expedite that, so that not even 2 days are wasted, it's very much within the gift of the prosecution and the victim and witness unit to volunteer and provide that information to the witness, and so agreed facts can be reached. The prosecution, of course, have given certain details of expenses that they have made directly themselves to this witness. But, Your Honour, we say that's the tip of the iceberg, and we've seen that in relation to other witnesses. There's a whole sea of other expenses that a witness receives from the victim and witness unit to which the defence is not privy, to which we are not given access. We say that there's no good reason for that, and the victim and witness unit can easily prepare a schedule detailing the payments that they have made to this witness and the dates and the amounts, and if necessary, if it's by M-Pesa transfer. We don't need more information, but it would be helpful to the defence, and it may enable the counsel for the witness to agree or stipulate as to certain facts that will even obviate the necessity of the phone records. Of course, if the counsel says they're incomplete, there's nothing to stop those phone records being obtained later on, even in the course of testimony, and for those to be provided and given to the chamber. Your Honour, the conception, of course, from the prosecution is that the conception in Kenya is that often there are benefits to being a prosecution witnesses in terms of pecuniary advantage, and that leads certain witnesses to say that there's a luxurious lifestyle. So that issue, the merits or otherwise, can be properly focused by the victim and witness unit providing information they have to the chamber, to the defence, and of course to the counsel for the witness. Your Honour, that will probably help any allegations in the affidavit to be properly disposed of and assessed by the chamber.
PW, I think this will be a logical point for you to come in your submissions, and after that we'll hear from the CSS. Okay.
Thank you very much, Mr. President, Your Honours. Maybe first on the last point, and if you allow me, then I will come back on the question raised this morning. But on this last issue, we've been indeed the receiver of an email of the defense of Mr. Song asking for some information of financial nature. We already had some discussion in front of this chamber on the sensitivity of this kind of information and on the need for the VW to receive clear instruction from the chamber on the need for us to disclose those. Our preference would be for disclosure to the chamber, for the chamber to decide if there is a need for further disclosure, or if the expenses that are made by the VW are of reasonable nature. So I think we discussed at length the specificity of financial data in the past, but if you need me to explain further, I can.
Mr. Khan, Mr. Kigan Katwa did indeed intimate earlier on during his own submissions that he will be or has filed papers or will be filing papers.
That is true, Mr. President.
Are you privy to that, and whether or not the papers he filed would have covered in writing what you had in mind in your last submissions just minutes ago.
I'm grateful, Mr. President. I understood my learned friend to be saying that he intended to file on Wednesday. I haven't had a discussion with him about that. I haven't seen those documents. The first I heard about it was when he was on his feet. Your Honour, we've had for some months dialogue with the Victim and Witness Unit generally seeking such disclosure. And we've always had the same kind of response that no, this is a matter for the trial chamber. But we do say generally for this witness and others that we're not asking for any details, for example, at this hospital or this school or for this institution that would somehow disclose the location of a witness. But we do not see any valid reason to deny the defence a list of the amounts spent by this court, by the Victim and Witness Unit, on a witness. Your Honour, from a witness's perspective, anywhere in the world, who are not lawyers particularly, whether an expense comes from Victim and Witness Unit or OTP or the court, if it's related to these proceedings, it may have a certain effect. And we say we should be given that information. There's no reason for that to be hidden by the Victim and Witness Unit away from the defence. And the arguments that somehow it would imperil a witness is not sustainable, we say. The balance of convenience is disclosing it to the defence so we can make submissions. Your Honours, we hope we try not to make bad points. If it's valid, we will not waste the court's time. But if cumulatively expenses are such that it may cast the testimony or the behaviour of a witness in a certain light, it should be disclosed to the parties and, of course, to the lawyer for the counsel for the witness as well. Your Honours, we know, for example, from the last witness, $43,000 was spent on that witness alone, and that information came after the witness had been released.
All right, let's do this. Mr. Kigen-Katwa, when would you file your papers?
By Wednesday, Mr. President, we will have filed.
By Wednesday.
Yes.
Let's do this, Mr. Khan. Let's so that we don't deal with this matter piecemeal. To the extent that we can deal with the rest of the issues now before us, let's do those. When Mr. Kigen-Katwa files his paper, we'll see if that will sweep in everything.
I'm grateful.
Thank you. Ms. Shada.
Thank you, Mr. President. Just to confirm that the instruction that you issued this morning before the break were transmitted to our team in Kenya. We are currently conducting the vulnerability assessment by a VW psychologist and via video link. So we should be able to report back to you on the fitness of the witness to testify soon. We need to emphasize that normally these vulnerability assessments are conducted with witnesses willing to testify and appear, and that we need the witness full cooperation to be able to complete our work. So depending on the behavior and the willingness of the witness to talk to us, then we'll be able to provide you with a comprehensive report on that subject. So the assessment is conducted at the moment and would include the potential risk of further psychological harm for the witness if he were to testify. In addition to that, and considering the certificates that were provided to the VW, the medical certificate, we will address the witness to a specialist. In Kenya, we are currently trying to have an appointment in due course in order for another certificate to be issued for the witness. I also wish to highlight that we have qualified VW staff, support staff on the ground that are used to deal with stressed witnesses or witness expressing some fears about testifying. So they are there and available for the witness to provide their services.
And indeed, this is something of an expertise of yours so far, because one can recall that as it's only in the minority of cases, I think, that we have had witnesses who have shown up here without indicating complaint. So you have had to deal with that sort of thing in the past.
Yes, we do, Your Honor, and we have staff among our staff that are qualified to deal with this kind of situation. Sorry.
Now, before you, I know you would get in the submissions, or rather respond to some of the submissions made in the course of the morning by lawyers, especially from submissions were received from Mr. Mutai. But just to get some of those points out of the way, when the prosecution, who Mr. Steinberg was submitting, he indicated that it was no earlier than the 3rd or 4th of August, or even the 10th of August, that the information came to you for the first time that this witness might have issues with health. Before that time, you had nothing of the nature. Can you speak to that? When was the first time you...
Sorry, Your Honour, I think you might have mistaken what I'd said. What I'd said is that neither on the 3rd nor 4th nor on the 10th were any health issues brought to the attention of VW as far as I knew. Not that only on that date it had happened.
That's even worse.
Yes.
That's okay.
I can confirm that in our previous interaction with the witness, there was no discussion or no health issue raised. So the first time the VW has been made aware of such issue recently was when the medical certificate was provided.
And how extensive was your contact with the witness before this information came in? How many times had you had contact with a witness in the past, up until the 29th of August?
The contacts I'm referring to are the contact that we had early August with the witness.
Are you able to tell us between that and the 29th of August, how many other times you've had contact with a witness?
What happened is that we had contact and we indeed received the passport of the witness in order for us to get the visa. This procedure was completed on 6 August, and then we tried to re-establish contact with the witness, but we were not able to do so before really recently, when discussion were about his appearance. I will need to go back to my colleagues to give you a specific record of our interaction, but it's something I can provide to the chamber later this afternoon if you don't mind.
Yes, please. You may do that.
Shall I proceed?
Yes, please.
I just wanted also to touch upon the point that was discussed about the need to familiarize the witness and the length, the duration such familiarization would take. The statement reading is a time-consuming part of the familiarization. What the rest that the VW can do in the specific situation of a video link is a short in-court familiarization to explain to the witness and to have him test the video link facilities so that he won't be surprised. And I heard Mr. Khan saying that we should not lose time, but this is a quite short process and we highly suggest to conduct it because it has demonstrated in the past that it would make the witness at ease, more at ease when he has to face the judges and the parties and participants. And this, once again, should not last more than 1 hour, and it's already scheduled to take place after the instruction you gave. It's already scheduled to take place today, right after the hearing. For the rest, it is statement reading. In our possession, we have more than a statement of 32 pages. We have 3 statements in total. In addition to that, 1 annex and 2 documents to be read. So it may be a bit more time, between 1 and 2 days for the witness, depending on how fast he is to read these documents. but this can be completed. And once again, we have all the material available in Kenya, and we can assist the witnesses with the statement reading. And actually, right after the vulnerability assessment, and if we still have time, the witness must be still able to focus, but whenever we have a chance, we can start the statement reading with him, today or tomorrow. So this can be completed quite easily.
Private session, just 1 minute or two.
We're in open session, Your Honors.
Nishada, can you?
I see that Mr. Steinberg would like to answer to this question. So.
Your Honours, if I may, perhaps I'm in the best position to speak to this. I can confirm that, without giving any identifying information, the witness has deposed to 3 separate statements to the OTP. 2 of them were deposed to in July 2013. The first is 32 pages, although it is a fairly dense statement. There's a lot of information in it. The second is only, which was taken on the 14th of, well, before I get to that, the first statement has approximately, let's say, about 15 annexes, 19 annexes. They're mainly photographs and sketches. It shouldn't take too long to look through. The second statement is only 9 pages long, but annexed to that there are extracts, or in fact copies of 2 diaries kept by the witness for the years 2007 and 2008. And that would be the bulk of the 150 pages referred to by my colleague from the VWU. The relevant portion of those diaries is really just 1 month of the year. It's December 2007 and to the beginning of January 2008. I don't think it would take, the witness would presumably be given an opportunity to scan through it, but the relevant portion is a little bit shorter than that. And then the third statement from November 2013 is again approximately 10 pages.
Once again, I may be a bit too cautious on the duration, but this is based on our past experience. It may be quicker, and what we can agree is that the VW can update the chamber as soon as the witness complete. If the witness completes the reading in a few hours, then we can update immediately the chamber when it's completed, and we can. Yeah. That was the point I wanted to make, but I'm available if you have any further questions for the VW.
So do you have any more to submit, or you're done? Okay. Thank you very much. Ms. Prada?
Thank you very much, Your Honor, Mr. President, Your Honors. Maybe just as a matter of order, the registrar is represented today, besides Natasha Schauder, acting head of operations within Victims and Witnesses Unit, Ms. Verachi Wang, Associate Legal Officer in the immediate office of the Director of Court Services, and myself, Esteban Peralta Nosilla, Chief of the Counsel Support Section. The registry is indeed not here to take a position on whether the testimony of the witness should take place or be postponed, but rather to provide the Chamber with the relevant information on the actions taken to ensure the effectiveness of the right of the witness to have legal advice as provided by Rule 74. This effectiveness is guaranteed by the presence of duty counsel appointed by the registrar, counsel who is on the list of counsel and has travelled a long way to assist the witness. This appointment also was made in full conformity with Rule 73 of the regulations of the court, and it was done only on Friday evening, after noting that the Counsel Support Section had not received the application of Mr. Gregory Mutai to be added to the list of counsel. Mr. Mutai had been informed on Wednesday, August 27th, of the requirements to be added to the list. He announced some minutes after my first message that he would forward his application before close of business on Thursday, August 28th. At 17:54 on August 28th, CSS wrote another message to Mr. Mutai informing him that we had not received any application from him, and that was the last communication with him on this matter. CSS can indeed make an expedite provisional assessment only on the eligibility of Mr. Mutai to be added to the list of counsel, but there is always a bare minimum information required. Being very flexible, a duty-completed application form would be enough for CSS to make a provisional assessment for this purpose. Thank you very much, Your Honor.
Mr. Mutai said that he is applied to be added. Is that your information or not, as we speak?
Yes, as I have said before, CSS has never received Mr. Mutai's application to be added to the list of counsel. This does not necessarily mean that he never sent such application. It may be indeed that there has been a mistake in the address to which the message was sent, and if the address was sent to the correct address but included attachments of several megabytes, it is possible that the server has refused it. In that case, the sender should in any case have received a message communicating that refusal. Also, as I said, on Thursday at 17:54, we sent to him another message saying that we had not received anything from him. The IT section of the court has explained to us that they might be able to find any message sent and refused by the server, but we need to provide them with a printed copy, a scanned copy of the message itself, so that they can trace it inside the server.
Thank you.
Your Honours, thank you. Just one point that occurs to me that before the floor is handed back to Mr. Mutai, he might wish to address in his response. And that goes to the issue of the selection of suitable counsel to represent the witness under Rule 74. And we've heard from Mr. Peralta that at some expense, counsel has been sent all the way to Kenya. But I just raise one issue which may be of concern to the prosecution, and that is an issue of a potential conflict of interests with regard to Mr. Mutai. It seems fairly apparent that the provenance and reasons behind the witness's affidavit recanting his earlier evidence may be an issue that will have to be addressed during the course of his evidence. I note that Mr. Mutai was the advocate who deposed, who took that deposition and administered the oath in that regard. It may be that if there is any dispute about the conditions and the reasons for the deposing to that affidavit, Mr. Mutai himself could be a witness to that. At the very least, there would seem to be a risk of a conflict of interest that may arise. So in determining the suitability of two alternative counsel, the prosecution submits that that is a factor that the Chamber can reasonably take into account in exercising its discretion to appoint counsel to represent the witness. Thank you.
Why do you say that it was Mutai, Mr. Mutai rather, that, do you mean it was Mr. Mutai that prepared the affidavit? And of course there's nothing wrong with that. Solicitors always generally take instructions and put it down in writing. I'm not saying that's the case here. And witness deposes. Or are you saying that it was Mr. Mutai acted as a commissioner for oaths? What are you saying?
Your Honours, from the face of the document, the third page, there is a signature which appears to be the signature of the deponent. His name appears in print. It says, sworn at Nairobi by the said name of the witness on the 11th of August. And then there's a stamp, Advocate Commissioner of Oaths.
It's a different name from Mr. Mutai, isn't it?
Yes.
Yes.
Sorry, I hadn't noticed that. I just noticed the name of Mr. Mutai.
So you are mistaken on that?
It seems that I am. Yes,
right,
thank
okay.
you.
All right, we'll leave it at that. Mr. Mutai, we're about to pass the microphone over to you, but before we do, there's Mr. Debre sitting next to you. Mr. Bray, you've been sitting patiently all along. Now, you also wish your intervention at this stage will be necessarily limited, and it will be this. In the event that you are appointed for the witness, or rather the chamber gives you that assignment, are you in a position to indicate how long it will take you to have the witness understand? In other words, would you need 21 days, 3 days, 5 days, 2 weeks? What would it be?
Mr. President, Your Honours, I am in a very difficult position to make any assessment about that for reasons which I will briefly explain, if you will allow me, Mr. President. Although I've come here, as you have noticed clearly, the witness has his own lawyer, his own counsel, so I have not spoken to the witness. I am not privy to any of the material that he deposed, so neither the statements given to the prosecutor's office nor the affidavit that has been talked about. And I would say, again, I cannot answer the question, so that's a short and good of it, but I would like to add one more comment, that if the danger of a breach of Article 70 looms, or even looms large perhaps, from what I've heard, it is of course of the highest concern that proper counsel goes through that issue before the witness gives statement, and that's my final remark. As the witness has a lawyer of his choice, I think that should weigh very heavy on the decision, or as regards to the decision you have to take. And I would, with these minor remarks that I am allowed to make, feel very much for the option or the solution perhaps of a provisional listing of my learned colleague who's sitting next to me. And from what I heard from Mr. Peralta, sending the duty application form, which could of course be done if there was some mistake or whatever, it could be done in the course of the next hour or two, would probably suffice. So, and that's my final sentence. I think that, in my humble opinion, would be the most sound solution.
Thank you very much. And Mr. Mutai, now over to you.
Mr. President, thank you very much. I would like to begin by responding to the submissions made by the representative of CSS in regard to my application to be put in the list, to be enrolled in the list of counsel. Mr. President, I made the application on time, within the time frame I had mentioned to the registry and to the relevant office. And on Saturday, last Saturday, I wrote a reminder to that office in regard to the status of my application. Mr. President, I have printed out copies of the email exchanges, emails that I sent to that particular office in regard to my application. It's true that because of the number of annexures that I attached to that application, that the document was voluminous. Be that as it may, I have not received any notification that there was failure of delivery. I therefore believe that application reached that particular office. I don't know why they do not have it at the moment, but I can show the the staff of the court present with me the copies of those correspondence so that he can verify for himself.
Right. Can you do two things in that regard? Would
Yes.
you do that?
Yeah.
Give copies of your previous application
Yes.
to the registry staff there with you, and in any event, apply again immediately.
Mr. President, I would request for 3 minutes to retrieve those records from the rest area where the documents in my possession.
We can do that later. You don't need to do it this moment. But as soon as we are done, if you could attend to that.
Yes. Mr. President, I wish to respond to the issues which have been raised by my learned friends in regard to my application for reference to the medical ability of before the our submission is that present is contested. Contradicts that assertion has been made by my learned is subjective. Assessment of somebody's mental very definition can carry out some Mr. President, a person's capacity of physics where can be done a given situation with certainty. Who made these reports gave his particular details, phone details, to practice medicine and been contested, and his can be assessed. In view of that very fact, particularly this report be taken by the court of the witness to testify before. The second issue that in regard case,
I want to ascertain of your last point about accepting it is. You that we give a direction that the witness is to subject and opinion. You suggest
that is not my suggestion, Mr. President. We are in agreement that attestation on a medical report requires a different medical report legal to legal professionals are not to
you're saying we should a medical expert, and you do not object to a second.
Yes, Mr. President.
Corridor with process.
Yes, Mr.
Okay, proceed, please.
The issue of fair. Our submission is that liberates the Rome statutes and fairness involved in this procedure. Now, faced with a situation, stated status. Regard to his particular witness at this particular point. And the Honorable Court, he may not be able to do so. Time frame, my learned suggested. Council, the duty council, some to go to the document may be produced, statements 200 pages. Establish testimony that he gave. Why instances to divert a bit of time. Mr. View.
Sorry, Mr. Point. Also, witness coming in from the include the reality time. Witness and that means to take it or goes the that you high priest that affidavit gave you the substance of what they were saying. Interested in communicating a position in which you advise on 25th. So just to you.
Mr. President, that statement that I was given by the points of what he now the the statement to be Article 70 would be sufficient guide on his testimony. My learned friend what basis this particular witness. Our submission in regard to two in the rules, the trial chamber special orders. We have in mind and rule evidence. Rule 18 provides that a chamber may hold or a request under sub-rule 1 if determine any special measure, including but not limited to or a family member testimony of the provides for situations as curiae to represent situations where the possibility of situation arising it would be necessary that presented can be in regard the other statement on we made with the email dated August 20. Our submission in regard to Mr. Steinberg's submission particular email and of provision regard statement that the witness under head for production of that statement would be necessary. In any that statement has not been provided to the witness, but to be able of
I'm back. which I'm going to and you will also need to respond to it. 70 execution is able to say, if they takes a stand, he says proceedings will be used against the Rule 70 proceedings and get on with things.
President, Article 70, of course. 70.
Thank you, Mr. Speaker. Rule 70 execution undertaken. Says the court must, the court may execution is able to say that come up with to a large
Mr. President, of course, be to in of the witness preparedness on our part. Go.
Mr. Stein, question.
For the sort of regarding self-incrimination under rules provided kept confidential to the public and indirectly against that person by the court. Understanding of that proviso at the reference to, in other words, to this witness any evidence amount to an offence under Article 70.
You can undertake that while the at least you will or information goes of his not form an article execution or 71.
The purpose of the prosecution get relevant events of 2008. It is not an attempt to evidence which may be used against him in any subsequent carte blanche to the witness, but on any matters in which to question this witness in regard to such an undertaking.
Yeah, yes, you had items of I just accept is that the prosecution that they will not seek to prosecute any alleged moment of takes the witness does not tell the truth in relation to what the to the oath 70 are there as a safeguard to feel the seriousness and the solemnity of the occasion. They can't
happening. The extent of the immunity 74. It is use immunity before this court for any crimes. It
on the same page. What we're trying to do here, we know what you're saying. The point told and have a right outside of here to proceed. That you when evidence this witness gave in court trusted and outside and process.
I think the undertaking Article 74.3 is quite clear. Witness may feel free to speak entirely freely before he says before this court can be used against him or will be used against him for any subsequent process.
Would I proceed? Much finish your reply.
Mr. Minutes. Both the witness and I on issued
The witness.
President. Witness this matter, or rather disposed of seeking adjournment is not something. If he had the state of is what we have difficult so that to intention gets a senior counsel by the office in charge of a list of the senior counsel involved in this would make his application and those two applications made quite obviously, assuming that more time is testimony. We are granted that we seek. Those come, we've exhausted the that we are given both the senior counsel and myself. And so, therefore, there is no possibility that there will be issues of indefinite deferrals being requested in the course of these proceedings.
when were you called to the bar?
I was called to the bar in 25th of May.
Thank you. Please proceed.
Yes. Now, I wish to reiterate in closing that although the is not a the situation, even after the assurance has been given, is such a lot more time is necessary so that he can testify. And I would reiterate that a period, even if not of 21 days we've requested, but almost therefore, we our prayers accepted that a certain parole is the kind of period
Very much, Mr. Mutai. Mr. Parata, Mr. Kanmani spoke earlier in the morning, said something about a provisional assignment, realization of assignment of counsel. Is that something that's possible or that's done? And how does that work?
Yes, indeed, the provisional admission to the list of counsel is a common practice within the registry when there is an urgent need of a lawyer and where the client has a lawyer that he or she trusts. We have done that in several times, but as I explained before, previous intervention, we need a bare minimum of information to make such an assessment, and so far we don't have that bare minimum.
What would be the barest need for a provisional assignment?
The barest minimum, Your Honor, it would be, I think, the candidate's application form duly completed. Even if it's not supported by documents, we would give the candidate a reasonable period of time to submit the missing documents. But we would be able to make a first effort to make a provisional admission to the list if that would be warranted by the information contained in the application form.
If Mr. Mutai passed on the that registry staff in Nairobi, would that at least serve the purposes of the provisional side?
The provisional decision would be made probably before the end, if that happens within the next 20 to 30 minutes.
Right. We will be adjourning and resuming tomorrow. In the meantime, Mr. Mutai, you will need to file those papers to the CSS. It will be advisable, perhaps helpful, if you apply in the usual course and then give copies to the registry official with you there, either, and then again file later, whichever one is more convenient. Since you're there, if you've got the papers with you, give it to them. This is a suggestion, not an order to you. Suggestion. staff, and then use the regular communications channels. Both avenues available to you as we speak, hopefully to try and deal with that on the list of council.
I'm well guided, Mr. President.
We will meet again. Yes, Mr. Khan.
Mr. About to adjourn. This morning, probably fall for consideration tomorrow. Answers have been served. We have had no communication from the park, and we've been sending a lot of emails to the prosecution about what on earth is happening. We need to know what witnesses we have to prepare for, and I'd ask that the bench, I don't know if an order is required, encourage the registry to tell the defence which of the three summonses have been served. They've given that information to the prosecution by the registry, and we say there's no reason for that information to further handicap defence preparation. That information can be given today, and that will help us focus the preparation without delay for the next witness.
The prosecution, you do have that information?
Your Honours, we also have not received. I had victims and witnesses unit, the officer responsible for being communicated formally to me. I understand that there is Your Honours, there's Chamber's attention before we adjourn. The under witness will be back to court tomorrow. I wonder if he could be brought into court and formally bound over.
I don't think it's under compulsion. In the last to take place between the prosecution, the registry, and the parliamentary service, and my understanding, service, that the witness has been willing to come to court.
His lawyer said.
The authorities have that has volunteered
scheduled witness take witness, and we did not.
Mr. President.
Yes.
I would like to make to the me that his application also at the same time as mine, subject to making that particular application.
There's nothing wrong at all with to be on the list. Trust you, I checked, I'm still on the list. Make his application That puts you don't wear the silk for it. Jurisdiction put 10 years. So, fine. Let's get back to the registry. Somebody wanted to address the court.
Thank you, Your Honor. The registry would like to clarify that we did receive the proof of the service of the summonses for 3 witnesses out of 4, and the registry is in the process of preparing the transmission filings. However, the package was not complete, and we're liaising with the Kenya government to consent towards the complete package. That's why it's delayed. And this transmission, we got the document from the Kenya government really late after working hours on Friday, which should be 29th of August, 2014. So therefore, we're preparing the transmission filing. And what our prosecution was saying that we give information was during the break, and we just gave a brief information that the prosecution was informed the chamber that they received information from the registry, which is during the break.
So you will be filed?
Yeah, in the course of today.
Yes.
We'll be in an urgent filing today.
Thank you very much. So we'll leave it at that. Now, we will adjourn and we will return tomorrow at 9:30, all of us, including Mr. Mutai and the witness. Tomorrow, 9:30 our time. Are we on the same time zone? They are ahead of us.
We're 1 hour behind. Kenya's 1 hour in front of
Yes,
us.
so that makes it 8:30 their time.
Indeed.
Yes.
No, 10:30.
10:30.
9:30 here is 10:30 in Kenya.
So we're ahead of them.
Yes.
All right. So then,
No, we're behind them, Your Honor.
whatever.
Kenya is ahead. So 9:30 here is 10:30 in Nairobi.
Okay. Good. So let's adjourn at the same time as we did today. Meet again tomorrow at the same time. Thank you very much, and we will be adjourning now.
All rise. We will